Sound check. Can you hear me? Sound check. Testing 1 2 1 2. Cool then. Afternoon, honorable members. I request that we start with our meeting. The program for the induction is shared among the members. I believe that we can take less than the scheduled time, but that will be informed by our cooperation and engagement. There's the program, but I just want to check whether there are any apologies. Okay.
Thank you, Honourable Chairperson, and good afternoon. I just want to apologise. I unfortunately have to leave by 5 o'clock, if I can be excused then. Thank you.
Okay.
Thank you, Chair. I just want to submit an apology on behalf of Mr. Nodada. Thank you.
Thank you.
Chair, we have two apologies, one for Mr. Manyi and the other one for Mr. Ndlozi.
Okay. But I think the quorum allows us, and I believe that the induction didn't warrant and does not warrant any quorum.
Yes,
if members
It doesn't
were
require
informed.
columns,
Yes.
because there's no decision to be made.
Okay. I propose then that let's a mover for the adoption of the apologies. But I believe that by 5 possible we'll be out. We'll take an hour and we'll be out by then. But we depend upon yourselves, Mr. Ngaleka, and our cooperation. I don't know whether there's a need for us to introduce, as it is our first meeting, to introduce ourselves. My name is Weziwe Tegana Kotiwe. Let me move this side.
Good afternoon, Chair. I'm George Michalakis, Chief Whip of the DA.
Good afternoon, Chairperson. I'm Honorable Mahlaula, a member of this committee.
We are on introductions.
No, thank you very much, Honorable Chair, and greetings to honorable members and the support team from Parliament. I'm Mr. Kichimani Skosan from the ANC. Thank you very much.
Good afternoon, Honorable Chair and honorable members and support team. My name is Nongeba Kalega Mazibuko. I am representing the ANC. Thank you.
Thank you, Chairperson. I'm Wouter Wessels, representing the FF Plus member of the committee.
Thank you. Let me go this side to Mr. Ngaleka.
I'm Victor Ngalega. I work for the NA table. Thanks.
Okay, same, it's Oli Sitoti. I also work for the NA table and provide secretariat support for this committee. Thanks, Chair.
Good afternoon, Chairperson and honorable members. My name is Andy Letejana, and I'm from Legal Services. Thank you.
Hi, my name is Jerome Adonis. I'm from the NA table. Thank you, ma'am.
Yes, please. Okay. You yourselves for us to know you as the support of the committee, not because we don't know you, but we want to identify you, link yourselves with the names and know you better. Let me welcome you to the meeting or to this induction. We understand that it should have taken place a month ago, but because there were other programs which members were preoccupied with, and we were unable to continue with the induction. We felt that it's necessary for us to be taken off with the work we're going to do as the committee. For us, whenever there will be any reference or referral to the committee, we'll deal with those matters which are put before us as the members of the committee. We are here to be inducted by the members of the NA staff as they have introduced themselves. I already indicated that we won't take a long time, but as we believe that whenever there's a case, we'll be afforded an opportunity to reflect on issues, and we'll be able to be supported with the legal advice as it will be warranted to do so. Welcome to the induction. We'll cut off the tea time as we have already dealt with the matter. Hence, I was saying we won't take long. At this juncture, let me hand over to Mr. Ngaleka to take us through. Thank you.
Thank you, Chair. The presentation is divided between myself and my colleague Andy Tijana. I will start first and then he will come in later. Let me just preface by saying, Chair, I'll focus on the matters that are directly related to the committee and only mention the other rules that are applicable to the committee. For example, the composition of the committee is determined by the other rules that determine composition of portfolio committees. The NA Rules Committee has decided that this committee, like portfolio committee, has 11 members, 4 ANC members, 2 DA members, 2 MK party members, 1 EFF member, and 2 members from the other parties. We have received the name of Mr. Vessels from the other parties. We are still waiting for Mr. Ghana to supply us with the other name so that the committee can be fully composed. Secondly, when it comes to quorum or decision making, the rules that apply to committees apply to this committee. For a meeting to start and proceed, at least a third of the members of the committee must be present. That is, 4 members must be present for a committee to start its meeting and proceed. However, to take a decision, a majority of the members must be present. That is, 6 members out of 11 must be present to take a decision. And where there is a tie, the chair has a casting vote. That is, she can decide matters one way or the other. Okay. Besides her deliberative vote. Okay. This committee is a standing committee established in terms of the Powers and Privileges Act. Rule 211 of the rules gives effect to that, to the Section 12 of the Powers and Privileges Act. When it comes to the meetings of the committee, Rule 213.2 requires that when the committee deals with a matter that relates to a member, the meeting must be closed. And it must also be closed because it also is a confidential matter. Okay. Unless the committee decides to open in the public interest. What that means is that the committee must make a determination. Firstly, does this matter relate to a member? Secondly, is it a confidential matter? Okay. If those 2 requirements are met, the default is that it must be closed unless the committee decides in the public interest to open it. Then when the committee deals with other matters that are of a general nature, then it must be open, just like other committees. Now, let me deal now with the mandate of the committee. The mandate of the committee is to deal with 3 matters. One is matters related to contempt of parliament. Secondly, to deal with misconduct. And thirdly, to deal with a request from a member of the public to have a response recorded. That relates to a member of the public who is aggrieved by what a member has said in the House or in a committee meeting. A member of the public can write to the Speaker or to the Secretary to Parliament and ask to have a response to what the member said. The Speaker is the person that refers matter to this committee, whether it's contempt, misconduct, or a request to have a response recorded. And then the committee must investigate the matter in terms of the procedure set out in the schedule, to which Mr. Tekana will speak to. Okay. Now, in terms of the rules, contempt is defined in the Act. Section 13 of the Act defines what constitutes contempt, and Angela will deal with that. I'm not going to expand on that. Misconduct is defined as a breach of the NA rules. Okay. But it doesn't include a breach of the conduct of the code of conduct, as it is in the schedule to the joint rules, or is it contempt as defined in the Act? So misconduct only is applicable to the rules when they are breached. When a member has been found guilty of contempt, then the committee is required to make recommendation on the appropriate penalty in terms of Section 12(5) of the Act. Now, when a member, when a request has been received from a member of the public, the committee is required to inform the affected member of the grievance or a witness, because sometimes the grievance could be as a result of what a witness had said in the committee. Then what would happen is that the member or the witness will be informed of the grievance, and they'll be requested either to come before the committee and give their version of what they had said, or to give a written response. The grievance doesn't constitute an allegation of misconduct on the part of the member. What the member would have said in the House is not a misconduct, unless the Speaker or the NA rules felt it was a misconduct. The Section 25 grievance procedure is a remedy for members of the public who are aggrieved by what is said in Parliament, so that they will come before the committee and say, this is what a member had said about me. For example, in the 5th Parliament, the former Secretary to Parliament, Mr. Mgidlan, had a complaint against Mr. Shivambo. Mr. Shivambo had said that he's corrupt, things like that. He wrote to Speaker, the matter was referred to this committee. The committee asked the member to respond to the grievance. The member didn't take up the response. The committee looked at the grievance and satisfied itself that there's been no finding against the then Secretary of Corruption. And therefore, that grievance was sustained. A response was published by the committee in the ATC. Similarly, a certain Mr. Makubela complained about what the then chairperson of the Brand South Africa, about what the chairperson then said in the committee. The committee invited the chairperson to give a response. In fact, the chairperson came to the committee. And after the committee had looked at both the grievance and the response, determined that the grievance was not justified, and it refused to publish as a response to that. So that's how the committee deals with grievances that are lodged with Parliament. Lastly, the committee can on its own initiative conduct research on issues of powers and privileges and immunities of parliament or upon the request of the speaker. That is the chair, briefly.
Thank you, honorable members. Are there any questions for clarity? Okay.
No, thank you very much, Chairperson. The examples you gave, the two examples you gave, the first one is of interest to me because, yes, we are protected on what we say in the chamber, which can be taken out and you are prosecuted as a member. But in that example, you upheld the complainant's grievance to say they were not wrong, they were never found to be corrupt. But a member has said, you are corrupt. Is the accused only getting recourse by a publication of the statement that says, no, he is found not to be corrupt and nothing happens to the member? Is that my understanding? Nothing ever happens to a member. If I can be clarified on that, thanks.
Yeah. Oh, through you, Chair. Yes, that is correct. The member is not charged with either contempt of misconduct. This is just a remedy that's provided to members of the public to put their side of the story and have it published. But what the member said in Parliament still stands because it's protected by privilege.
Meaning there's no apology through you, Chair?
No.
Okay.
Yeah. Unless the speaker had referred the matter, but it doesn't come through the Section 25 procedure. It will have to come via other processes. For example, if the member had said something in the House and the speaker ruled that to be unparliamentary and maybe ordered the member to withdraw, there is a provision 71 which provides that we don't use that procedure, Section 71, because it has matters that were through another provision, Section 74, 73. Okay, let me just explain what that procedure. If the speaker is of the opinion that in order to withdraw or to leave the House is insufficient, then the speaker could order other measures. For example, he might feel that that matter is so serious, he or she must refer to this committee for investigation. But we have proposed to presiding officer not to use that procedure because at the moment it provides for an automatic suspension of a member for at least 5 days initially, 10 days and 25 days. Now, that provision was also in Rule 73, and that was struck down by the courts. So we don't use that provision until we have amended it such that it allows the speaker to say that in order to withdraw is not enough, you need to go to the Powers and Privileges Committee for misconduct or for contempt.
Yeah, no, thank you very much, Chair. And we appreciate the presentation from Mr. Ngaleg. Yeah, just two questions from my side. One, on the issue of closing the meeting. I've noted that we were saying when we're dealing with issues affecting members, the meeting should be closed. However, the committee may decide to open the meeting. But I just want to understand what is the rationale of closing the meeting, because we believe in the spirit of transparency Hence, meetings of parliament are open to the public, even the media and so forth, including hearings and ad hoc committees that deals with conduct of heads of Chapter 9 institutions. All those meetings are normally open. They are only closed if there's a portion that is deemed to be confidential. It will only be closed for maybe that day or that hour, but ordinarily, all meetings are open. So why in this committee the meetings are normally closed? They only be open if the committee decides to do so. Why are we not saying meetings are open, but then if there's a need, then the committee can close the meeting? Why is it the other way around? Secondly, I think there's an example that you gave of the chair or the former chair of the PEN SALP. So I want to understand what powers do we have on people who are not members of parliament? If a leader of a certain structure or a certain stakeholder said something in a committee, in a portfolio committee, and then what powers do we have over such people? Because those people are not members of parliament, they have not taken an oath and stuff like that. Thanks, Chair.
Thank you very much, Chair. Mr. Ngalega, please forgive my ignorance. If it is, I'm new in the committee, so I might be one of those slowest soldiers. ATC. What's the meaning of ATC? It's an acronym. I know it's very easy to use acronyms if you are used to them, but if maybe there can be a full name and then in brackets acronym, so that next time we all understand what does it mean. One of the questions I had noted, Honorable Kosana has asked in terms of the process, in terms of people who are not necessarily members of parliament. And then you've made one example, but I would like you to also take me through one example that has happened. There are members of the party. I was not a member, but I saw it happening. There were members of the party who were suspended. What process was followed there? Did it come to the Powers and Privileges Committee? And what was the process that led to their suspension and the act that was used thereof? You have made mention that when it involves members of the public, then Section 25 of the Constitution is used. Maybe the legal expert would maybe just to give us a synopsis of what does Section 25 say, so that at least, because this is an induction workshop, we have a better understanding to link the public involvement and the section. Thank you.
Last one.
Thank you, Chairperson. Chair, there's always or let me put it like this, the protection afforded to members of parliament in the form of absolute privilege is a very important protection. It's very similar to freedom of speech, but it can be abused just as freedom of speech can be abused as well. And there is provision in the rules with regards to the abuse of privilege. But it can also happen that a presiding officer might make a ruling to say that an honourable member must withdraw a statement that is actually reasonably protected by privilege. Let's say person X is a thief. That is reasonably protected by privilege. Not also in terms of former rulings and so forth. But it has almost happened that a certain a specific presiding officer will think that that is wrong, and abuse of privilege, and might then rule that it must be withdrawn. The question is, the procedure in Parliament is obviously that if a ruling must be challenged, it's referred to the Rules Committee. The question is, what is this committee's role in assisting in such a matter? Because the power and privileges function does fall here, and there's almost an overlap between the Rules Committee on that ruling before it becomes misconduct, because if it was misconduct that the member did not withdraw, refused to withdraw, then there would have been a complaint to this committee, and then there would be an outcome. Yes, it was actually absolute protected privilege, or no, it was not. Presiding officer was correct. The member is abusing his privilege in terms of Rule 355 and is guilty of misconduct. But if it's never referred to this committee, and it's only a challenge to the Rules Committee, my question is, can this committee assist? Is there any procedure in that regard? Has it ever happened before? So I think that is a void to a certain extent.
Thank you. Mr. Ngaleka, can you please?
Where my colleague feels that I've left out certain things, he will come in. Let me just deal quickly with the ATC. The ATC is one of the three or five journals of the House, where it's for purposes of record. Okay. It's the ATC that is used for, historically when they say we table, it was done physically. A minister would say, I'm tabling this and put it on the table of the House, but now we don't do it like that, except the Minister of Finance. Okay. Now, tabling is done by publishing in the ATC. Okay. That's tabling, hence it's announcements, tablings, and committee reports. Okay. So when this committee has finished a matter, and it tables the report by publishing it in the ATC. Okay. Similarly, with a request for a response to be recorded from a member of the public, if the committee agrees, that's very important, members, they are not bound by that report, by the version of the member of the public. They might say, look, although we see your point, but we are giving you this version. We will agree to your complaint if you agree to this version. And if the member of the public agrees, and then it will be published, okay, in the ATC. And then the other journals of the House will be order paper, which is really the agenda of the House, and the question papers and others. Those are your journals of the House. Okay. Mrs. Kusana, if you read the rule, it says the matter must relate to a specific member or members, and it must be of a confidential nature. So those two goes together. Then the meeting is closed. But if it's not of if the committee says that it's not of a confidential nature, then the meeting must be open. But it also says if both requirements are met, then default it must be closed. It should be closed, but the committee might make a determination, say, no, on this one, we want it to be public. The committee is given those powers. Okay. This is not like your Joint Ethics Committee, which is closed, which is not open to the public. Okay. This committee has the powers in Rule 167, which gives the committee powers to ask a member of the public to come to the committee and be a witness. And if the member of the public refuses, or if a member of parliament refuses, then the committee has the powers to summon that member. Then there's a procedure to issue summons and force the member of the public or whoever to come before the committee and produce reports or give evidence or whatever the committee might want from that member. Okay. So the committee is empowered to fulfill its mandate just like any other committee. The section, do you have the act? Section 25 of the act is just a grievance. It's a remedy for members of the public when there's a grievance, when they have a grievance about what was said about them. Let me just read it quickly, so it's not that long. Protection, that's the title, Protection of Members of Public. A person other than a member who feels aggrieved by a statement or remark made by a member or a witness in or before a house or committee about that person may submit a written request to the secretary to have a response recorded. The committee referred to in section 1212 must, subject to the standing rules, consider the request and, if approved, publish the response of the aggrieved person in the appropriate parliamentary. That's what it is about. The member, what the member said will not be count against him. The member might decide, I'm not going to respond. The committee must deal with the version of the complainant that's before him, whether it's justified or not justified. The section is in the Powers and Privileges Act, not the Constitution. Section 355, Mr. Vessel, has never been used, abuse of privilege. It's quite a tricky one, if I may just read it. The sub-rule 1 says, the assembly may make a finding that a breach or abuse of the privilege of the privileged provided in section 45(2) of the Constitution and 55 of the Constitution, or as set out in Rule 63 of these rules, which repeats what is in the Constitution, is contempt of Parliament as envisaged by section 13D of the Powers and Privileges Act in accordance with sub-rule 2. Now, what does sub-rule 2? The Assembly may make a finding in terms of sub-rule 1 only if the Powers and Privileges Committee has decided that a specified act constitutes contempt of Parliament and has reported accordingly to Parliament. We have never been here up until now. Maybe this committee is something that we'll want to investigate. Thanks, Chair.
Thank you. Are there any follow-up questions? If we don't have, let us request Mr. Tejana to present.
Again, good afternoon, honorable members, and to my colleagues as well. I'm just waiting for my colleague to flight the presentation. Honorable members, I was told to come and present the procedure to be followed in the investigation and determination of allegations of contempt of Parliament. Perhaps we should start from the beginning. I'll just give a brief background. The act we're dealing with, I usually like to refer to it as PIPLA. Powers, Privileges and Immunities of Parliaments and Provincial Legislatures Act. It gives effect to Section 58 of the Constitution, Section 58(2), which deals with privilege. And of course, 58 is only relevant for purposes of the Assembly. 71(2) only relevant for purposes of the delegates to the NCOP. And of course, section 1172 is only relevant for purposes of provincial legislatures. So for our purposes, we will only direct ourselves to section 58, 2. So what does this section say? It says that cabinet members, deputy ministers, and members of the assembly have freedom of speech in the assembly and in its committees, subject to its rules and orders. So in actual fact, it gives unfettered, it's an unfettered right in that way, I mean, as it were, to freedom of speech, but that is limited by the rules and orders of the assembly. Now, the act came into operation on the 7th of June, 2004, and of course there were amendments which were made emanating from court judgments. We'll talk about that later. Now, if you look at section 12 of the act, the section provides for disciplinary action against members for contempt. Now, my colleague, Mr. Ngalega, has touched a bit on this. So for instance, if you look at section 12 of PIPLA, 12.1 says, subject to this act, a house has all the powers which are necessary for inquiring into and pronouncing upon any act or matter declared by or under section 13 to be contempt of parliament by a member and taking the disciplinary action provided therefore. So if you look at subsection 2, says a house must appoint a standing committee to deal with all inquiries referred to in subsection 1. So this is the standing committee. So this standing committee is established in terms of section 12, subsection 2 of the Powers and Privileges Act. Now, if you look at section 13, section 13 gives us a bird's eye view into what constitutes, what conduct constitutes contempt. Okay, you can go. Okay, sorry. Now, you will see that in terms of section 13, the relevant provisions are provided regarding what conduct constitutes contempt. And of course it says a member is guilty of contempt of parliament if the member contravenes section 7. Section 7 deals with prohibited acts in respect of parliament and members. And of course section 8 deals with improper influence of members. Section 10 deals with giving evidence of proceedings. And section 19 speaks to unauthorized publishing. And section 17 speaks to offenses relating to witnesses. And then section 21, subsection 1, speaks to the broadcasting of proceedings. And section 26 speaks to hindering, obstructing of staff members. We will go into that a bit later. I just want to talk about this case, the Democratic Alliance versus the Speaker of the National Assembly. It's a very important case, and I think members of this committee must read this case. So this case emanated, okay, what happened in 2015, and I think all of us will remember this. In 2015, President Zuma was here, I mean, to address Parliament, and subsequent to that, members of the FF, you know, sort of like gyrated from what was the business of the House on that day, and asked him when is he paying back the money regarding the upgrades in Gandla and so on. And of course, when the Speaker was trying to calm them down, they became unruly. It's not me who says that. It's court documents, you know, in case there's a member of the FF here. So subsequent to that, because of the fact that there were members of the security services who were involved, in the removal of the members from the house. The DA approached the Western Cape High Court, of course, on various grounds, one of which was the question of, giving deference to the doctrine of separation of powers. And of course, the Western Cape High Court ruled in favor of the DA, and the Speaker appealed the judgment to the Constitutional Court. And the Constitutional Court, in a majority judgment, because there was a minority judgment as well by Justice Jafta, the majority judgment was written by Justice Madlanga. And just there are certain paragraphs I just want to, I think 1 or 2 paragraphs, which I think are important for the purposes of this judgment. Because what this judgment does, in my view, it sort of like gives us contours in terms of what is acceptable conduct and not acceptable conduct in the context of freedom of speech in the House. If, for instance, you look at paragraph 38 of the judgment, it says, surely the privilege contained in section 58, subsection 1A, and section 71, subsection 1A, can never go so far as to give members a license so to disrupt the proceedings of Parliament, that it may be hamstrung and incapacitated from conducting its business. This would detract from the very raison d'etre of Parliament. Section 57 of the Constitution provides that the National Assembly may determine and control its internal arrangements, proceedings, and procedures, and make rules and orders concerning its business. Now, the other paragraph I just want to quote is paragraph 44, which says, to warrant removal from the chamber, interference or disruption must go beyond what is the natural consequence of robust debate. Otherwise, the very idea of parliamentary free speech may be eroded. In the heat of a debate, one must expect that from time to time, a member's contributions will not come to a screeching, mechanical halt once the presiding officer has ruled that the member desist from further debate or the subject. Now, lastly, paragraph 45 says, interference and disruption that may be sufficient for the removal of a member must be of a nature that hamstrings and incapacitates Parliament from conducting its business. Even so, there must be no anticipation of resumption of business within a reasonable time. So I thought let's make that point very clear. So one of the issues that were challenged here was Section 11 of the Powers and Privileges Act. And the challenge that was mounted was that the section, as it read at the time, bordered on unconstitutionality. I just want to read the section for the members as to how it read before this judgment. So the section says, a person who creates or takes part in any disturbance in the precincts while Parliament or a house or committee is meeting may be arrested and removed from the precincts on the order of the Speaker or the chairperson or a person designated by the Speaker or chairperson, by a staff member or a member of the security services. So that's how it read. So the Constitutional Court said, if you read this act, the word person includes a member of Parliament as well. But then what the Constitutional Court did, it did what we call, it's a read-in. So it read in, okay. Section 11 was declared as invalid or unconstitutional in relation to members. So the reading in was a person. So after the person, they wrote in the words other than a member. So a person other than a member who creates or takes part in any disturbance. So that other than was read in by the Constitutional Court. Parliamentary free speech contained in section 58(1)(a) and 71(1)(a) of the Constitution is subject to the rules and orders and may not be regulated in an act of Parliament. I think we've dealt with that. And of course, what happened after that, Parliament had to, they had to introduce a bill in order to effect that particular amendment. And that was the amendment bill in 2018, as you can see there. Amendment Bill 2018 addressed the judgment, definition of disturbance excludes an act committed by a member in the exercise of his or her freedom of speech, as contemplated in subsections 58(1) and 71(1) of the Constitution, and providing that the arrest and removal on the order of a presiding officer of a person who creates or takes part in any disturbance on the precincts is not applicable to a member. And of course, these amendments, amongst others, clarified vague sections in the Act, and effected, technical and grammatical corrections. Okay, you can go to the next. Yes. So, this is exactly what I said is encapsulated in section 12 of the Act. But if you look at the rules of the National Assembly, particularly at page 215, you will see there, there's a schedule to the rules. And that schedule deals with the procedure to be followed in the investigation and determination of allegations of contempt of Parliament. And of course, if you read section 12, subsection 3 of the Act, it says, before a House may take any disciplinary action against a member, in terms of subsection 1, the Standing Committee must inquire into the matter in accordance with a procedure that is reasonable and procedurally fair. And of course, that's the procedure I'm referring to. The schedule to the rules speaks about that. Section 12, subsection 2B says that this standing committee must table a report on its findings and recommendations in the House. So a House may find a member guilty of contempt and may impose any one or more of the penalties set out in subsection 5. So if you look at section 12, subsection 5 of PIPLA, you will see that they've listed all the applicable penalties. Formal warning, reprimand, an order to apologize, withholding for a specified period of the member's right to use or enjoy any specified facility provided to members by Parliament, and so on. So that's the procedure I was referring to. If you go to page 215 of the rules of the Assembly. The procedure, I think, gives effect more than any other thing to the Audi rule. Fairness of the proceedings, reasonableness of the proceedings, and so on. So, if a member is charged with misconduct or contempt, then a written notice must be delivered at least 5 working days before the hearing. And of course, what you want to achieve there, you want people to go and consult, and so that when they are required to plea, maybe they've they've gotten some advice from elsewhere. And then the schedule speaks about legal representation as well. It says legal representation is allowed in certain cases. Usually what we have done in this committee is that, because we don't want to find ourselves in a territory where we're being accused of being unfair and so on. Because if you read the schedule, it talks about complicated or complex cases. And of course, the question then becomes, what do you mean by a complex case? What do you mean by a complicated case? And so on. So I think our approach has always been, if someone requires legal representation, all you need to do is to make an application to the committee, and the committee will accede to it. Written or oral explanation may be delivered by a member before or at the hearing. So what usually happens is that we usually appoint an initiator. It could be a member, of course, outside of the committee, or another person duly qualified. And of course, the functions of the initiator is to present the necessary evidence to the committee, cross-examine witnesses, evaluate the evidence, and propose penalties to the committee. And the charge member has a right to attend the hearing, or the hearing may continue in his or her absence. The affected member must plea. A plea explanation is allowed, and of course the default is no guilty plea. In other words, if the member is not here, there's no just cause for him not to be here, and the committee presses ahead and continues with the hearing. The default is a not guilty plea. So the charged member or legal rep may call witnesses and cross-examine them, or any other witness, to corroborate their case. The chairperson and members of the committee may pose questions. Of course, members do so only through the chairperson. We don't find that restrictive. We think it's a permissive provision in the sense that it's the chair who directs the meeting. If the verdict is a not guilty verdict, of course, that's the end of the matter. But if the verdict is guilty, then there are arguments in mitigation and aggravation in writing, or they may be in writing or verbal. And of course, a member may be suspended pending the hearing under certain circumstances, like, for instance, intimidating witnesses, this and that, and so on. Yeah, you can go. Okay. So these are just the sanctions, the penalties. And of course, I won't repeat them because they are listed in section 12, subsection 5 of the Act. I think the only thing that I just need to flag for the benefit of the members is that if you look at section 12, subsection 11 of the Act, the takeaway there can be that during the period of suspension, the affected member or members will not receive their salaries or travel allowances, but their medical aid and pension benefits will be unaffected. So that's the effect of section 12, subsection 11. If I may just go to it, this is how it reads. Despite the Remuneration of Public Office Bearers Act 1998, a member who has been suspended without remuneration under section 12(5)(g) is not entitled to any salary or allowances under the Act for the period of suspension. But the reason why I'm saying I'm flagging it is because the Act simply says that, it does not say, but their medical aid and pension benefits will be unaffected. Okay, we can go. Okay. So this relates to the suspended member. A member may not be suspended in terms of this provision unless the House has found that the member is guilty of a serious or repeated contempt, and none of the other penalties set out in subsection 5 will be sufficient. Of course, suspension of a member is quite a. I don't want to use the word draconian, but I'm just saying it's only in those instances where, for instance, is a repeat offender, and of course that's the kind of behavior that we want to correct. So a member suspended must leave the precincts and may not, during the period of suspension, without the written permission of the Speaker or the Chairperson, enter the precincts for whatever purpose or participate in any activity of Parliament. or any committee. Yeah, this has happened plenty of times, I mean, over the past 5 years. So a suspended member without remuneration is not entitled to any salary or allowance under the Act. I think I've dealt with that already. All right. So this is, oh, sorry. This is Rule 355, which speaks to the, I mean, abuse of privilege. And of course, in essence, it speaks to Section 13 of the Act, which deals with contempt of Parliament. So in this light, we merely deal with conduct constituting contempt, and of course, that is what is captured in Section 13 of the Act. As I said, Section 7 deals with prohibited acts, Section 8, improper influence of members, Section 10, unauthorized giving of evidence of proceedings, 19 deals with unauthorized publishing, Section 21(1) deals with unauthorized broadcasting, and 26 deals with hindering or obstructing staff members. And then we have Section 17. And Section 17 deals with offenses relating to witnesses. And then if you look at the Rule 10 of the Assembly, and I think that last point speaks to it. Rule 10 speaks about contempt of the Assembly rules. And it says a member who willfully, of course intentionally, fails or refuses to obey any rule, order, or resolution of the House may be found guilty of contempt of Parliament in terms of the Powers and Privileges Act. Next slide, please. Okay, can you show us the... No, there I was just talking about accountability and accounting, you know. That the reason that we find ourselves in this territory is that we are accountable as opposed to, you know, counting money as you do in the Standing Committee on the Auditor General. Yeah. Honorable members, I think I'm done. We can take questions. Thank you very much.
Thank you, Mr. Teacher. No chance, you are the first.
Thank you, Honourable Chairperson. Just an observation. Thank you for the presentation once again. Just an observation, Chair. You know, many years ago, I'm informed that the rules actually provided that if you were chased out of a sitting, you had to leave the precinct immediately. You were escorted to your office. That was now not gross misconduct and being removed by white shirts. That was just refusing to withdraw something. And you had to leave the precinct and you lost a day's salary automatically. And if there was then a finding that it was gross misconduct and so forth, it could be a greater sanction. So our rules are actually very lenient in that regard. That is what it is. And whilst I'm saying that, I am not a member that has never been chased out before, and my leader holds the record for being chased out the most. So just an observation. Thank you.
Thank you very much, Chair, and thank you for the presentation. I think it was quite clear, especially in terms of the acts. But I have one question, Chair, of clarity. Legal representation is allowed. So it just says in certain cases. Where do we see under which cases or circumstances that legal representation is allowed? Because you might find that there are members who might abuse this right to have a legal representation, or maybe us as a committee, we then say, no, the member does not qualify for a legal representation. So if maybe we can have just a sense of under which circumstances is because remember legal representation is an outsider, an attorney or a lawyer is outside, is an outsider. So if I can get clarity on that, Chair. I do have a clarity in terms of the suspension, under the suspension of members, because also I wanted to know the circumstances, but there's a page that clarifies it. Yeah, thank you.
Thank you. Honorable.
No, thanks, Chair. And we welcome the presentation from Mr. Chechan. There seems to be a thin line between misconduct and contempt of Parliament. I don't know if Mr. Chechan can just elaborate as to where do we really draw the line. Which instances do we regard as misconduct and which instances do we regard as a contempt of Parliament? And then in terms of penalties, which one is regarded as grave than the other? And now, secondly, on the penalties, I think there's the slide with penalties. I think one of the penalties, it says removal. Well, it says removal or suspension for a specified period of the member from any parliamentary position occupied by the member. Well, the suspension part I understand, but the removal, to say this committee, can we say somebody who's a chair of a portfolio committee, we are recommending that that person should be removed? Is it that one of the example, or can you give us maybe examples that relates to this penalty of removal of the member from any parliamentary position occupied by the member? Thank you very much.
Honorable Mick.
Thank you very much, Chair. I think on the slide, fair procedure, there is a third last point that the chairperson and members of the committee may pose questions. And then it says members only through the chair. What does it mean? I for one, don't want to come here and there is a witness there and I can't ask a question. Why don't you take the chairperson alone to conduct that hearing if we are not going to pose questions only through the chair that we can pose questions? What do you want from us? What does it mean in simple English, so that we are not at loggerheads with the chair when we ask questions to a person who will have graced us, unfortunately.
Thank you. Let me first welcome you for joining us. We scheduled 5 to 5:30 for us to attend the meeting. Okay. Was your hand up? Yes. Okay, you are the last one then.
No, thank you, Chair. I'm just reflecting on the fair procedure.
Sorry, Chair. Just an order. If the member could introduce himself,
Okay.
because we started with introductions before he arrived. Thank you.
Okay, thank you, Honorable Cele. We already introduced ourselves, so for the benefit of the meeting, can you please introduce
Yes,
yourself?
indeed, Chairperson. No problem. Nsamulo Nzela, and member of the committee, and member of Mkhonto Wesizwe Party. Still Mkhonto. No, thanks, Chair. Look, from my end, from where I'm sitting, this slide on fair procedure. The third point, and I think it was raised, is the issue of legal representation is allowed in certain cases. So at what point, do you not, or are you not allowed to have legal representation? Because then it goes back to the issue that the honorable member was also asking regarding the issue of misconduct, at what point do you classify, a case to be that of misconduct? So that's the first one. And then there was the issue of, let me just have a look. The charge member right to attend a hearing, and the hearing may continue in absence. A plea or pre-explanation allowed, the default is guilty or not. So if a member is charged, and I think it also touched on the charged member, the legal, yeah, that's it, sorry. The charged member or the legal representative may call witnesses and cross-examine any other witness. And I think it goes back to the honorable member's question as well. If you are allowed legal representation in certain cases, and then there's a case where you don't have legal representation, how do you then deal with the technicalities whereby the laws here, the rules still allow you to have legal representation at some point? You see, there's a bit of a challenge there in terms of, they seem to be conflicting. Yeah, thank you, Chair.
Thank you. Can you please respond?
Thank you very much, Chairperson. Chairperson, I'll start with legal representation. That's where I'll start. Now, if you look at the schedule to the rules, Chairperson.
Sorry, Chair, on that one, and if your legal representative can preside over your matter in your absence. Yeah, with that, sorry, that's part of that question.
All right. So let's start with that, Chairperson. So let's read the third point of the schedule to the rules. It says, in complex cases or cases involving complicated evidence or legal issues, and where the committee is of the view that such legal representation might be essential for a fair hearing, the committee may allow the member charged to be represented by a legal practitioner who is not a member. Now, let's talk about practice in this particular committee, because, I mean, in the past 5-6 years or so, we've been dealing with these cases. So practice has always been, and I mean, my colleagues will agree with me when I raise this. I've always said, even to council for that matter, that this particular provision, in my view, is unfair, and of course it borders on illegality. And I will tell you why. There's a principle in civil law where we speak about the equality of arms. For instance, what happens in this particular committee is that in terms of practice, we always appoint an initiator who is counsel. So in other words, an advocate of the High Court or an admitted attorney of the High Court of South Africa. So on the equality of arms principle, the point I always raise is that on the other side, you have counsel assisting the committee as an initiator, arranging and evaluating the evidence, leading witnesses, cross-examining, and so on. And on the other side, you have a member who is not represented by anyone. That, for me, swings the pendulum unfairly so favorably to the whims of the committee. And that's why we've always said in this committee in particular, that whenever that request for legal representation is made, we've never refused it. So, okay, it says, in complex cases, and the question will be, what do you mean by a complex case? Or cases involving complicated evidence or legal issues, and where the committee is of the view, so it gives that discretion to the committee, that such legal representation might be essential for a fair hearing. The committee may allow the member charged to be represented by a legal practitioner who is not a member. So those who are on the other side of the divide in terms of this argument have said if you look at the sanctions mooted out to members, the highest sanction that can be mooted out to a member is to suspend that member from the House for 30 days, and of course to dock his or her salary for 30 days. So they have said, because of the fact that you are not saying, there won't be a sanction where you say to the member, no, you must never come back to Parliament. I mean, of course, there's a reason for it, because members have been voted by South Africans and so on. So those who are on the opposite side of the divide have always said that, yeah, but why are you being pedantic, and technical about it? Because the highest sanction you can moot out to this person is to suspend them from the House for 30 days. But I'm still of the view that, I mean, as you know, if you are going to take a salary of the person and suspend that person, in all fairness, I mean, the procedure must be reasonable, it must be fair, it must be seen to be just, and so on and so on. So insofar as that is concerned, I can only tell you about practice. That practice is that we've always allowed people to be represented by legal representatives. That has never been denied. Regarding misconduct and contempt, you're right, there's a very fine line there. And I think in interpretation, what we usually say is that we distinguish between the general and the specific. And of course, the general is that conduct constituting contempt is spelled out in Section 13 of the Act. So in other words, anything that falls within the scope and ambit, any conduct, that falls within the scope and ambit of Section 13 will be deemed as conduct constituting contempt. And of course, if it's outside that, and it's on the other divide in terms of the rules or the law, we will then give it a name that it's misconduct. Look, you may not be happy with my answer, but I'm just saying practically, contempt is defined in the Act. And of course, we can only charge you for contempt based on whether what we have committed falls within the ambit and scope of Section 13 of the Act. Now, regarding Mr. Mahlaule's question on this thing of asking through the chair and so on, I think it's just for orderliness, if I may be basic about it. That's why I'm saying it's not a restrictive provision, it's a permissive provision, because meetings are led by the chairperson. And of course, if you want to ask a question from a witness, I mean, we've had inquiries in Parliament, I mean, and you've been part of them, I know, Mr. Mahlaule. No member has ever been restricted in terms of interacting with the witness. Thank you very much. Oh, sorry, there's a question Mr. Skosan asked as well regarding, let me go to the sanctions. There's a question. Yes. Where is that? Sorry, I'm just looking for. Yes, on the penalties. Oh, yes. It says the removal or the suspension for a specified period. Of course, that specified period cannot be more than 30 days. For a specified period of the member from any parliamentary position occupied by the member. I think practically what it means is that if you, Mr. Skosana, I mean, you are the chairperson of the committee, just making an example. So for that particular period, for that specified period, you can't be the chairperson of the committee. Let's say, for instance, the penalty meted out against you is suspension from the House for 15 days. The fact that you are suspended from the House means that you can't come here to the parliamentary precincts. And of course, you can't discharge your responsibilities as the chairperson of that particular committee for that specified period. So yes, we've removed you, but for that specified period.
The way it is written, it says removal or suspension. Now it talks about removal as a different thing, as a separate thing, that you can be removed or suspended. Removal or suspension. So in other words, it's not like you are not occupy your position as a consequence of being suspended. No, it talks about the removal as a separate thing, the way it is written. We'll say removal or suspension.
It's not on. Oh, sorry. It says the removal. For me, this is, and I'm trying to be practical about it. For me, if this committee, for instance, to any member for that matter, who is affected, who appears before this committee, if the sanction is that we're suspending you for 10 days, I'm just making an example. For me, that has got a removal effect. Yes, yes. So that's my reading of it for that specified period. Yes.
Are there any follow-up questions? Okay, Honorable Nkele.
Thank you, Chairperson. Firstly, this slide here speaks to fair procedure. Yet I think, advocate, it is advocate, right? No. Yes, legal attorney. From what I'm hearing you saying, based on how you then articulated that particular clause in the rules, seems to highlight that posture that we would take borders on illegality, because then it's the committee that will be making that determination as to whether you need legal representation or not as a member, which cannot be, because the committee has to preside over the same matter. So you are disadvantaged, and in effect, that law is punitive to a person that believes that they would not be able to preside over the matter themselves and therefore would need legal assistance. So I think it goes against the principles of fairness from a procedure perspective, because if I feel that this matter requires or needs me to have legal representation, I should be able to do so. And it shouldn't be the committee per se that makes the determination. That's where I'm coming from. So that particular prescript in these rules needs to really be looked into. Thank you.
Oh, I wanted to respond. Oh,
Honorable Mafia.
Thank you very much, Chair. Can we go to the section 24 of the Act itself, or the Act itself, where it speaks about duty of criminal courts in respect of members. I just want to give a scenario of, you see, when we're elected, when we contest elections, there's a list that is taken to the IEC. I'm not going to talk about political parties that do due diligence in looking for vetting, criminal records, and all of that. But IEC does that. And when you enter Parliament, we are satisfied that, like former President Zuma, we are satisfied that the law does not permit that he becomes a member because he has been convicted for more than 12 months. What happens to a person where, because I know that people who get changed don't go back to IEC and get vetted and give us as the public, or give the public the chance to object, like we are subjected to for 10 days or whatever days we are subjected to. For the public to object and say, we know something about this man, he doesn't qualify to be a member of Parliament. Or IEC saying, no, you don't qualify to be a member of Parliament because you have been convicted for more than 12 months. And that person comes because the replacement of members, there's no vetting, a person just comes in. What happens if we here in Parliament discover that this person was convicted, in fact, for more than 12 months, and they've already served for 6 months, whose fault is it when we start dealing with that issue? Where is it that we're going to be guided as this committee to deal properly with that person without breaking the law ourselves, but also doing the right thing about Parliament or for Parliament? I'm not sure whether you get my point. Thank you.
I think I'll leave that one to my colleague, Mr. Galega. I'll only deal with what has been raised by Mr. Ndlela.
I think that will be your last take, Mr. Ndlela, now. You can't arrive late and not apologize, then you are taking us for a long time.
Chairperson, let me apologize for not having apologized. In light of time, I felt, let me just get into it, but I apologize. It was in no way disrespectful. May I, just off the back of the Honorable's questions as well, because this is a critical one. If you look at our situation, for instance, pertaining to Judge Thorpe, he's also a good example of exactly what the Honorable Member is highlighting, right? That he came in post the elections and then nominated and then brought on to be a member of Parliament. And then the courts now, which is a process outside of a democratic process, which then allowed him to participate in the JSC, then says that the issue of impeachment, which is not even there, in terms of a prescription as to whether he can participate or not, is then used to exclude him from being part of the JSC. So why is it that when there's powers and privileges that are vested within Parliament and Parliament takes a decision, democratically so and by way of a vote, that it can get reversed? Now, I understand the issue of the point, I think my honorable member there is referring to, of section 47(1)(e), when it comes to, the IEC's process of the candidates of the electoral process versus section 47(1)(e) pertaining to members of Parliament, because those are two different things. Otherwise, IEC, it's not their jurisdiction to participate in anything that's got to do with Parliament decisions. In the same way, the courts shouldn't be interfering. But we have a case right now where there is a member that was democratically appointed to participate in a committee, and yet the courts infringe on Parliament's decision, as per the rules, as per the powers and privileges vested in Parliament, to have made that decision in the first place. So that is a situation that I think, especially off the back, because it links quite well with the question that the honourable member is asking. Thanks.
Except for the fact that it is outside the remit of this committee. So Mr. Ndlela, this matter has been traversed, by our courts, and our courts have pronounced, and of course, Section 165 of the Constitution says the judicial authority of our republic is vested in the courts. So I wouldn't want to go beyond what the full court, the full bench has said in this matter. And of course, it falls outside the remit of this committee to do so. So regarding the matter you raised about legal representation, I will not repeat what I've already said. Safe to say that if you look at Section 2 of the Constitution regarding the supremacy of the Constitution, it says that this Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid. And I want to repeat that. Law or conduct inconsistent with it is invalid. Now, the issue then becomes who invalidates? And the answer is simple. It's only a competent court who can invalidate. So my point is, to say something is constitutional or unconstitutional, the Constitution is not self-executing. So in other words, it's not my responsibility to say something is constitutional or unconstitutional, or senior counsel's responsibility for that matter, because ultimately it is only a competent court who can invalidate. So that's the question I wanted to raise. as long as this has not been challenged in a court of law, our views really remain opinions in terms of this paragraph 3 of the schedule to the rules. Thanks very much. I'll give over to my colleague.
Just briefly, Chair, just to clarify a point that was asked by Mr. Vessels. No speaker or presiding officer has the authority to impose a salary deduction on members. The power is to withdraw or to remove physically members by force. In the past, I said the speaker or the presiding officers had the power to suspend in terms of Rule 71. It's called naming or suspending. But I said that that power is no longer used because the court have ruled that there cannot be an automatic suspension without due process. Okay. Now, on the issue of contempt and misconduct, this committee doesn't have the power to initiate investigation on its own. It acts on the basis of referral. The speaker in the referral will ask the court, this committee to investigate contempt or contempt and misconduct. And sometimes it will specify, But yeah, it's the ambit of the investigation will be what we get from the speaker to investigate. On the issue of a member who has been sanctioned, we had a member, I think, in the 5th Parliament. She was from the Eastern Cape. I think her name was Yolanda. Chair, remember her name? Yolanda was Yolanda was a member. Huh? I think no, not Yolanda of the DA. It was the ANC member. That member was from the Eastern Cape. BCM. Yeah? I think so, yes, I think so. She had a case going on for her when she became a member. She was found guilty. But because there was an appeal, she was allowed to continue to being a member. It's only when the appeal was unsuccessful that she lost, because she was sentenced to house imprisonment, basically. And then that's how she lost her membership of the house. Yeah. So we have had one case like that where a member was sentenced whilst being a member, and then we acted on the pay. And that matter, fortunately for Parliament, it was in the public domain, so we got to know early.
So it means indirectly any member can write to the speaker. Then the speaker refers to.
Yes, there must be a complaint. For example, the DA had a complaint against Mr. Paulson, and the speaker referred that matter to this committee. Recently, there was also another complaint against Ms. Mkwabane for what he had said in public, and the speaker declined that because it doesn't fall within the ambit of this committee. It was not a matter it was not contempt or misconduct. Probably it was a matter for a breach of the code of ethics. So the speaker would sort of act as a filter to what comes before this committee.
I think if there are no other questions, this brings us to the end of the meeting. I know we might have some interest in engaging on other issues which are not related to the one, but for today, let's focus to what we were here for. And I appreciate that members attend. We'll hear on when can we start with the work. We only work when there are items referred to us. Let me thank you for attending this meeting. It was not an easy day today. The day was full of many commitments, but we sacrificed our time and prioritize the meeting. Thank you, the meeting stands adjourned.